Mahatma Gandhi once said, "The true test of a society is how it treats its most vulnerable members." This quote captures the essence of our criminal justice system, protecting the innocent and ensuring that justice is served. Today, we are gathered here to celebrate the launch of my father, Vivek Sood's 7th book, titled Chaff and Grain: Guilt, Innocence, and the Dilemmas of Justice. The book is a culmination of 3 decades of his experience as a defense counsel. It is a critique of the Indian criminal justice system as we know it, from the perspective of a senior counsel who has argued thousands of cases, cross-examined about 500 witnesses, and worked closely with the inmates of Tihar jail as a pro bono initiative. The book talks about the functioning and the malfunctioning of this system at every stage of a criminal trial. In this hard-hitting take on the criminal justice process, the book delves into how the innocent end up as under trials, the misuse of the power of arrest by the police, unjustified denial of bail, manipulated investigations, and fake encounters. The book also examines some of the most controversial cases to hit the headlines in the past 2 decades. Arushi Talwar, Jessica Lal, Priyadarshini Mattu, the Telgi fake stamp scam, and the Nirbhaya rape. Apart from making out a compelling case for reforms, this book tries to redefine hate speech and sedition. It will talk to you, question your beliefs, force you to think, and leave you stunned all at once. On that note, I would like to extend a warm welcome to our Honorable Chief Guest, Guest of Honor, panelists, Honorable Sitting Judges, Honorable Retired Judges, Senior Advocates, members of the Bar, family and friends who have joined us today. Our chief guest today is Honorable Mr. Justice A.K. Sikri. Though Justice Sikri needs no introduction, I must say a few words about him. Justice Sikri is an eminent jurist and a former judge of the Supreme Court of India. After retiring, in 2019, he has been appointed as an international judge at the Singapore International Commercial Center. Justice Sikri has delivered numerous landmark judgments on different branches of law that has changed the Indian legal landscape. Just to cite a few, in 2011, as acting Chief Justice of the Delhi High Court, he treated a letter addressed to him by a lawyer as a suo motu public interest litigation. The letter highlighted the illegal practice of falsification of age of children resulting in their treatment as adult criminals and the subsequent incarceration as adults in jail. He issued comprehensive guidelines for various agencies aimed at the elimination of incarceration of children as adults in jail. It was in this judgment that he introduced Age Memo as a legal tool to document and record the age investigation by the police. In the case of National Legal Services Authority, Justice K.S. Radhakrishnan, along with Justice Sikri, penned the historical judgment granting legal recognition to gender identity, whether it be male, female, or third gender. For him, human dignity were not just words written on a paper or something that should be preached emptily. The words that he wrote and spoke were the words that he lived by, believed in with all his heart, holding it in the highest pedestal, whether it was in his judgments, speeches, or interpersonal interactions. We are honored to have you with us today, sir. Our guest of honor today is Honorable Mr. Justice Anup Jairam Bhambani, who is a sitting judge of the Delhi High Court. Sir was designated as a senior counsel in 2014. During his days at the bar, he has done substantial legal aid work before various courts for the indigent embroiled with the law, including in the field of juvenile justice and death penalty. He has assisted the Delhi High Court as an amicus in several matters involving issues of public significance, which has culminated in laying down procedures for affording speedy justice. It was Sir's passion for justice which made him give up a very successful legal practice and serve as a judge of the Delhi High Court in 2018. A judge is known for his judgments, and I've selected a few of his many gems that have been delivered by him till date for today. Recently, in a case dealing with a bail plea of an 18-year-old who was accused for a sexual crime against a minor girl of 17 under POCSO, Justice Bhambani held that prima facie there was a consensual physical relationship between the two, and though POCSO was intended to protect children from sexual exploitation, it wasn't meant to criminalize consensual romantic relationships between young adults. In Muhammad Hakim, Justice Bhambani, while granting bail to an under trial who had spent 12 years in jail in connection with the 2008 Delhi serial blasts case, said, and I quote, "We must save constitutional rights from demise." We are pleased that he has been able to join us today. Justice Sikri and Justice Bhambani share certain exemplary qualities. They are ever-smiling judges, full of patience. Lawyers come out smiling from their courts even after a dismissal. Before we move on with the evening today, I would like to thank LiveLaw, who will be live streaming this event today and ensuring that the cause that we wish to celebrate reaches far and wide. So, without further ado, let's dive into the first segment of the evening, a panel discussion on the dilemmas faced by the Indian criminal justice system. Our panel today comprises of a distinguished group of senior advocates who bring a wealth of knowledge and experience to this discussion. Our first panelist today is Mr. Vikas Singh, Senior Advocate. Sir is the President of the Supreme Court Bar Association and is known for fearlessly standing up for the causes of the bar. A philanthropist at heart, he has been a major proponent for children's education. Our second panelist today is Mr. Mohit Mathur, Senior Advocate. Sir is the President and the heart of the Delhi High Court Bar Association and is known for promoting the interests of young lawyers of the bar. Next on the panel, we have Mr. Siddharth Dave, Senior Advocate. A suave personality, Sir is a passionate proponent of criminal law reform in India. We also would like to thank Sir for agreeing to be a part of this function on the last moment. Last but not the least, on the panel, we have Mr. Vivek Sood, the author himself. Today's discussion will be anchored by none other than Ms. Rebecca Johns, Senior Advocate. Ma'am needs no introduction. She is the first woman to be designated as a senior counsel by the Delhi High Court on the criminal side and is an inspiration to all women of the bar today. Each of these senior advocates have made significant contributions to the Indian legal system and have fought some of the most high-profile cases in the country. So, let's get ready for a lively and informative discussion on the Indian criminal justice system and the dilemmas that it faces today, with a unique perspective of senior advocates who may argue fiercely against each other in court, but are good friends outside of it. On that note, I would like to invite the panelists on stage. I would like to now hand over the baton to Rebecca, ma'am.
Firstly, I'd like to congratulate Vivek on this wonderful book, which we've all had the pleasure of reading. And it's really important that you're engaging with criminal law, which otherwise affects the rights and liberties of so many of our fellow citizens. And it's been a fascinating read. Thank you very much for this wonderful book. When I was asked to anchor the session, Vivek told me that essentially, since we've got these heavyweights on the panel, we should ask them what are the dilemmas facing the criminal justice system. And I thought that I would begin this discussion by placing the facts of a case which I recently had the fortune or misfortune of appearing for the client, a case that came from Rajasthan in which the accused was a young boy of 19 years and was convicted by the trial court, sentenced to death of the charge that he had raped and murdered a 7-year-old child from his own village. The High Court also upheld the conviction, but decided not to grant him the death penalty. It was reduced to life. In the Supreme Court, where I was engaged to argue for him in the SLP, I noticed that there were two essential pieces of evidence against him. One was last seen, which really was very tenuous because there was nothing last seen there. And the other, which mindlessly both the trial court and the High Court relied upon, was a DNA report. When we examined the DNA report, we came to the conclusion that not only did it exonerate this young boy, but it also pointed to the involvement of somebody else. Of course, when I argued the matter in the Supreme Court, the bench would have none of it, and the SLP was dismissed. The state had also moved a petition challenging the High Court's order converting the death to life, and had asked for enhancement of sentence. It came up before the same bench. At that point, it was noticed that since the High Court had not undertaken a discussion on aggravating and mitigating circumstances, it would be proper to remand the case back to the Rajasthan High Court, limited to the aggravating and mitigating circumstances of the crime and the criminal. Naturally, the counsel appearing for the accused brought out the DNA report as a mitigating circumstance. And this time around, when the Rajasthan High Court looked at that report, they were horrified at how much they had missed in the case and how unfairly this young man had been convicted. In their excitement, they wrote a couple of extra paragraphs which perhaps they should not have, and that necessitated another round of litigation in the Supreme Court, and the Supreme Court then decided to look at the matter. Mercifully, the death sentence was not, that plea was not allowed, but he was asked to undergo life. Now, this is the story of a young man from a vulnerable community who very clearly hasn't committed the crime. So when we talk of criminal justice system, the question that comes to mind, and which I want to throw to the panel, is there justice in our criminal justice system? And in the order of seniority, I'll ask Mr. Vikas Singh to answer that question.
So it's a very important question, but before I answer that, I must congratulate Vivek for this wonderful book that he has written. especially on a topic which is a burning topic in India, I would say, because when I put my points across, you'll realize how important this topic is and how necessary it is to have a proper relook at the present criminal justice system in the country. So congratulations, Vivek. As far as the point made by Rebecca is concerned, I'm very firm of the view that in India, what is really necessary is to get police reforms. Because what is happening in most of the cases is that, and which is also partly covered in the book, that the police, since there is no accountability and since they are also, not answerable in many ways in their normal routine, that they end up, picking up the wrong person to show that they are doing a good job, or rather that they have solved the crime, and in the process they leave the real accused. And this is what probably has happened in the case that Rebecca pointed out. So they appear to have filed a charge sheet that they found the criminal, and they charge sheet him. Whether there is evidence or not is not important for them, because the whole purpose of what they did was to let off the real guy, and for which obviously they must have been at the lower level paid very heavily. And in the process, you just see the ordeal that an innocent person has to go through for maybe years or maybe decades to suffer this trial. And ultimately, in this case, unfortunately, he didn't even get final acquittal, which he should have in the Supreme Court. But he may not get acquittal also, and sometimes he does get acquittal at some stage of the proceeding. And that really is the bane. And there have been efforts by, there was a former DG of UP, Mr. Prakash Singh, who filed a PIL in the Supreme Court, and he I think he did a great job by, getting directions issued by the Supreme Court that there should be proper police reforms. But unfortunately, no political party in the country is interested in police reform, because whoever is in power doesn't want to give up the control on the police. And that is how, if the politicians want to tamper with the investigations, the police get a free hand, because then they can't be held accountable for the other cases that they do. Because anybody, if you ask him to not do a proper job in some cases, then that gives them the freedom and the liberty to do the same in the other cases as well, and the politician has no face to ask him to do his job properly. And that's how that's the real bane of our system. In fact, as Rebecca pointed out, I also had fortunately, I had the fortune of getting an acquittal of a similar kind, where this boy was, traveling from Jammu to somewhere outside Jammu, and he was to buy he had a small shop, and he used to buy stuff for his shop, and he was carrying some 20,000-30,000 rupees, and he was stopped at the border, and the police saw that money on him, so they said to give some money. He said, "Why should I give you any money?" So then when he didn't pay any money, they arrested him and showed that he was carrying with some drugs. And the boy got convicted by the High Court, by the trial court and the High Court. And fortunately, this case was referred to me by retired High Court Judge Justice C.K. Mahajan. He knew the family, and he told me, Vikas, of course, the family didn't have money. So he said, you have to do it pro bono in Supreme Court, and this is this boy, and he told me the story. This is actually what has happened in this case. But of course, his saying could not have got him an acquittal. Fortunately, I could find out, remember this is a long time back, I could find some lacuna in the investigation, and I could convince the Supreme Court and got that boy complete acquittal. But that's very rare in our system to get acquittal in such cases. And really speaking, even, I mean, you all must have heard about what happened to Aryan Khan. Aryan Khan was not having any drugs at all on his body, and he was still arrested, and there was no reason, because that branch of law, according to me, that jurisprudence, narcotics narcotic jurisprudence is entirely based on possession, and without possession to arrest somebody who's not accused to be a dealer in drugs. I mean, if you are a dealer in drugs, that's a different issue. But even if you don't possess even a single gram or even a small quantity, there is no question of being arrested. And still, a person of his, backing had to undergo 1 month of incarceration. So these are the banes of the criminal justice system. And I say, unless the police reforms happen, because everything starts from there. If the investigation, so even if the right person is caught, and if the investigation is not done properly, Justice Kaul mentioned very recently that we are not to go by what the media says about a particular case. We have to go by hardcore evidence that is before us. And if the evidence is not coming, then there is no option with the court but to acquit him. But unfortunately, what is happening today, and that's again a problem which as lawyers we face day in, day out, that judges are also getting influenced by what is coming up in the media, and they tend to, convict not on the basis of evidence but on the basis of what their perception is. And according to me, that is not doing justice in a criminal trial. So I think that mostly covers what Rebecca wants, but she wants something more specific. I'll be most happy to answer.
Mohit, to you next. We often talk, and I think most of us recognize the fact that the investigation in a lot of cases is flawed. And there is a lot of talk of that in judgments. But do we simultaneously also recognize the fact that the justice delivery system, namely the manner in which courts appreciate these cases, are also sometimes flawed? And courts do not pull up investigating agencies as much as they should for the failure to conduct a robust investigation, and sometimes act as, they cover up for the flaws of the investigating agency. So in your experience, do you also feel that the criminal justice system suffers because courts do not ultimately stand up enough for the rights of citizens?
As Vikas Singh sir also said, I'd also, before I answer Rebecca, I'd like to congratulate Vivek. I didn't get a chance to go through the complete book, but definitely I find that his daughters were the inspiration for him to compile all his anecdotes and his critiques into this book. And perhaps, barring a few tidbits here where I didn't agree with his conclusions, but he did voice the concerns of most of the defense counsels. So congratulations, Vivek. I think it will go a long way for other budding lawyers, especially on the criminal side, to be wary of certain things, be careful about certain things, and then proceed with their matters. Now coming back to what Rebecca asked, I think, can I call you Becky? Yeah.
You can call me.
I think Becky has asked a question which she was perhaps the best person to answer. All defense counsels keep on crying hoarse that investigation is generally flawed, but somehow, over the years, in our experience, the courts have started allowing and giving more indulgence to the investigating agencies than the accused or the defendant or the litigant before it. It's an unfortunate thing because courts are actually presumed to be the guardians for all the citizens, and they have to presume that the defendant before them, the accused before them, is innocent till there is sufficient material to hold him guilty. I firmly believe what Vikas Singh sir also mentioned, that not just police reform, but add to it, scientific investigation is required. There's got to be some kind of scientific evidence which should link the accused with the crime, unless and until it's a case of where the eyewitness account is there or something. Today we are presuming too much against the accused. Every time a matter comes, the minute an FIR is registered, it's splashed all over the media. WhatsApp University keeps on controlling all the opinions and professes what, according to it, is right. Now, there is a problem which comes up with it, and that is, even the judges, the courts, they're not gods. They're also humans equally watching the same TV, the same media, and howsoever they may want to keep themselves away from any biases. The question of that little bit of window, which ought not to be given to the investigating agency, is generally given to them rather than the accused. So, in fact, the travesty of justice comes from the fact that the courts are neither pulling up the investigating agency to be on the right track, but sometimes they substitute their judgments and their methods, despite it being deprecated by the apex court, that you are not to investigate or tell the investigating agency how to investigate. But somehow, the track is, and probably it's what we always argue, that it's being done as a backward integration of the facts. That you hold the man guilty, you have already presumed him to be guilty, and then you go backwards how to find him actually guilty and what all to be built up from the stage of the allegation and accusation. So actually, it's the agencies which are being given powers far beyond what it can control and far beyond what they ought to be given. Be it police, be it other agencies, because today's devil in the society, we all know, is not the police agencies, but the newly coined ones, the SFIOs, the EDs, and the other agencies which have come up. They are the ones who are actually now building everything, and everything is going on presumptions. It's like, sir just had water. It was half glass full or half glass empty. So, what should be taken in the favor of the accused is instead taken against the accused, which makes it even more vulnerable. And I think all of us have umpteen number of cases to cite where innocent people were dragged into the litigations. Now, who will turn the clock back? And I always, the case, although I did not do the case myself, but I am reminded of an episode where a TV journalist got a sting operation done on a principal of a school regarding trafficking of the girl children and the girl students. That lady, I saw her only hapless in the Patiala House courts, being dragged, pulled by hair by the parents of the different students. She was beaten back black and blue, not by the cops, but by the public, who had thought that she is actually trafficking in her school. And finally, after a month of investigation, the police found out she was absolutely innocent. It was a setup. It was a setup. Now, who would turn the thing? Who is going to put as much in the newspapers to say that she is actually innocent? Who will put all that in the minds of the parents, and will they go to apologize to her? Because I only saw her, that part of it, and I actually felt sorry for her, that neither the agency, in fact the agencies who were bringing her, allowed the parents to come near her and bash her up. So, Rebecca, you're right when you say that the courts should pull up the investigating agency in the manner in which they do the right thing, not in the manner in which that, look, you have come to me with this accused, better clear everything, ensure that everything is in order, and if there are any things which are the faults, the flaws, the lacunae, which were the dictums of the court were that they are lacunae which cannot be filled, you cannot backtrack on these things, Today, at every remand, at every arrest, at every bail, the police and the agencies, the authorities concerned are allowed to cover up and patch any flaw or any gaps that are left. So, criminal justice system immediately becomes flawed if the man who holds it just becomes flawed, the man who holds the sword actually, the sword of justice, if he starts putting that sword at the neck of the accused rather than the police. So the sword is always there in that statue that we see, along with the balance, but that sword is actually to keep the agencies at bay so that they should not unnecessarily harass innocent people. Unless and until the presiding officer takes charge and takes charge of the right of the citizen, the justice system will be flawed. And sir is right. Police reforms, the scientific investigations, do anything that you want, unless the men who man the system improve their mindset, we cannot change this, and we'll continue to cry horse.
Thank you, Mohit. Let me come to the author. Fascinating title. I imagine you were inspired by the separation of falsehood from the truth. In your research for this book and the various cases that you have cited, what was the conclusion you reached? Was that separation an effective separation? Was that separation made at all? Or was it all jumbled up?
First of all, I must thank the co-panelists, Justice Sikri, Justice Midda, for being here. Chaff and Grain is a principle of evidence that has been evolved by the courts. In the American legal system, if a testimony is false in any material particular, the entire testimony is rejected. Now, if you were to apply that principle in India, every accused would be acquitted. Every criminal trial would lead to an acquittal, because the Supreme Court has said time and again, every testimony contains falsities, embellishments, embroideries, exaggerations. Therefore, the principle of chaff and grain has evolved, which means it is the duty of the judge to separate the falsity and the truth and arrive at a just conclusion. Now, in my view, it is almost a divine function to separate the chaff and grain correctly and precisely in every case. Therefore, in my submission in this book, I have said that chaff and grain is a principle of necessity for the Indian criminal justice system, but it is contrary to the Blackstonian principle, which says 10 guilty men may go scot-free, but when one innocent man should not be incarcerated. There is a conflict between the Blackstonian principle and the chaff and grain principle. But chaff and grain is a principle of necessity that we have to live with in our criminal justice system. And therefore, I have said in my book that chaff and grain will not lead to the correct conclusion in all cases. Innocents do get convicted ultimately, right up to the Supreme Court, because the application of this principle of chaff and grain is almost divine in nature. And I have in fact picked up case studies where I have said that the case ultimately led to a conviction, but the case could have gone the other way. To say that this is the false part of the evidence and this is the truthful part, to draw that Lakshman Rekha is a very, very difficult exercise. So therefore, there is a kind of a jumble up, or in other words, we have to live with this principle. But having said that, the law of perjury has to be activated. falsity has to be punished. You can't have witnesses lying on a platter and ultimately the chaff and grain being separated and the accused being declared innocent or convicted. That should not be the end of the exercise. If falsity is found in a testimony, then the accused, the witnesses who commit the falsities must be brought to book and must be prosecuted.
In fact, we're very grateful to have Justice Sikri here, and one of your iconic judgments was the judgment of State of Maharashtra versus Ankush Maruti Shinde, where a few, I think, nomadic boys from Maharashtra who were on death row and who stumbled through the Supreme Court in many mindless rounds of litigation. Ultimately, the matter was looked into by your bench, and you found them innocent and even ordered compensation. So these were men on the death row, and compensation was ordered for their false implication. They had been picked up some 10 years before, and you analyzed the judgment. The chaff and grain was separated in the judgment, and you came to the conclusion that these men ought never to have been convicted. So that was really an example of how in criminal law evidence should be analyzed, and it can have far-reaching consequences. In this particular case, a bunch of young men who had been incarcerated were freed, and compensation was ordered for their false incarceration. Siddharth, to you now. In fact, one of the first chapters of the book, Vivek talks about innocent accused and criminal victims of crime. And while it's easy to talk about these innocent accused in the context of 498A or the promise to marry cases, it's very tempting to talk only about it. But we do not necessarily talk about the false cases foisted by the state against citizens. The cases under UAPA, the cases under PMLA, cases under, as Mohit said, SFIO, where there are twin conditions, triple conditions, multiple conditions to fulfill before a man is even let out on bail. Isn't it time, therefore, when we talk about false cases, we focus on the one area that we are sometimes hesitant to talk about, and those are cases where the state shows its power on innocent citizens and ensures that they're incarcerated for years on end?
So to answer that, of course, it depends much on the judges about whether they are able to see it or not. I can primarily answer it from the perspective of Supreme Court. Now, when I joined, you had specialist criminal law judges. You had the likes of Justice M.K. Mukherjee, Justice Anand, much later Justice Bedi, Justice Sirpurkar, and the last of the specialist criminal law judge who probably retired was Justice Lalit, I think the one who practiced extensively on the criminal private side. But that doesn't take away from the likes of Justice Sikri, Justice Nariman, who have given us very path-breaking judgments on the criminal side which have benefited the accused. Now, the power of the state somehow has got emboldened, and the power of the accused has got diminished because of the administration of justice that is being done by the courts today. And according to me, it's a top-down philosophy that is followed. Generally, whatever the Supreme Court starts following or laying down is what is followed by the High Courts and the Supreme Court. So if in the last 10 years or 15 years, starting with that Amarmani Tripathi judgment, if Supreme Court is more concerned about cancellation of bails rather than grant of bail, then the courts below will not grant bail, because they know that once we grant bail, it will ultimately probably the High Court or the Supreme Court, it will get cancelled. Or even acquittals. And now rarely do you find a Sessions Court granting acquittal in a high-profile case. Rarely. Possibly because I'm told the administrative committee or the judge in charge probably will say there was something fishy because big people were involved or something. So let us take up this case of that judge. Why has he passed this acquittal? But it wasn't so earlier. There were many, they were absolutely independent. So I really do think that the message that is sent is from the top, which is the Supreme Court, percolates to the High Court and then to the lower court. But to answer your question specifically, if in our country, in case of, instead of the laws, the judiciary standing as a bulwark against the laws which is violating 21 of the citizen, if you're going to sort of support the state action, then obviously then there is no recourse for the citizen or anywhere to go, and our job is only to plead. It's the judge's job to decide. We can't ask them to decide in a particular manner. We can only plead that. Some judges are good, some judges are bad, and justice itself is quite relative. What we say, not in the context that you mentioned, but justice itself is relative. Meaning to the victim, who's an actual victim, an accused should not be let out, or to the accused or his family, he should be let out. But apart from that, this concept of this economic offences, or to be in custody for 7 years, or even 436 say that you have to complete half the sentence. Why should I complete any part of the sentence? You file the charge sheet, I should be let out. Trial will take time. It's enough. But we have a sort of a reverse system that we follow. Your bail is, being in jail is part of the punishment, because the judges also feel that, look, the case is weak, he must have done it, let him be in custody for 2.5, 3 years, and then ultimately he'll walk out, he'll probably be free, he's influential or whatever. So that is the method that we are following. It's more like a practical approach to all these things. But that's the way it is. But since the conversation is quite heavy, and there are some non-lawyers also, I was reminded on the criminal side, there's a joke that there was once organized and I'm sorry if I don't mean to sort of lessen the seriousness of the gathering, but there was a competition organized between various investigative agencies of the world. So there were the Israelis, there were the US, the Scotland Yard, and of course there was Indian police represented by Delhi police in special this thing. So they all had to take the task in a forest. A bear had been let loose, and they had to go and find that bear in the forest. So the Israelis were the first. They came out in they found the bear, 3 hours, they came back, followed by Scotland Yard, followed by the Americans, etc. Now, as time went by, they started wondering, the day drew to a close, and the Delhi police was not to be found anywhere. So they said, okay, we'll wait a while, this thing. Next day also they waited. Delhi police couldn't be found anywhere. Third day, no. So they said something must have happened to him. Let's have a search party for Delhi police. Said, okay, let's go. So then they found, they had waded deep into the forest, and they found that the Delhi police had tied a dog and was beating up the dog and saying, "Bol tu bhalu hai, bol tu bhalu hai." So that is the way that our investigation takes place, which is based on coercion, Section 25, confession, recovery, and that's the end of the charge sheet. Now it's not my headache. I've got transferred from here. Whoever has to deal with it will come and give evidence, and that's the way it goes. So practically, yes, many reforms, as has been suggested by the co-panelists, but ultimately, where will they come from? From the looks of it, the state is not interested in reforming these aspects. In fact, it's becoming much more stringent as far as, and we are not getting help, or we haven't got any help from the courts as well. Thank you.
I just want to add to what Siddharth has said. You know, he spoke about some judges who did substantial criminal justice. I would want to add that very few defense counsels are elevated to the High Court. Most prosecutors become judges. And you know, we find most state councils become judges, and we find that they don't leave that DNA of being a prosecutor even after they become judges.
But there's a very simple reason for that. Sorry to interrupt. The moment a defense counsel's IB goes to Justice Sikri, who's number 2, it'll have his client is Mukhtar Ansari, this one, so-and-so,
yes,
so-and-so,
yes,
in the IB report.
So you know, all defense counsels are badmash. They are all badmash counsels.
No, who will make him a judge? And the prosecutor is safe, all right, he's always been on the prosecutor, so there's no question of anyone. I mean, if your clients are all the criminals of the world, nobody will make you. Your IB report is wrong in any case.
Okay, let me try and pull this back. Mr. Vikas Singh, the near impossibility of getting bail in today's India. How did this happen? Because as criminal lawyers here, when we manage to get bail, we kind of tell our clients that the story is over, you can go and take a break now because it's unlikely you will be convicted. So the whole focus is on the bail hearing. When did we become this country, or when did we begin to celebrate this jurisprudence of jail, not bail, and move away from Krishna Iyer's jurisprudence of bail, not jail? How did that happen? You've been practicing for a substantially long period of time, so I'd like to hear it from you, the journey of bail, not jail, becoming jail, not bail.
So, bail, not jail is a journey which Siddharth partly mentioned. I mean, it was there in his, the drift was there. I can elaborate on that a little more. So, the way the way the senior judges or the higher court judges look at the lower court is that if this lower court judge has granted bail, then probably there is something wrong with him. So the jurisprudence in criminal trials starts by, if a trial court judge really feels that you need to get bail, whether he feels it on the basis of what is before him, or even if he's corrupt, he's taken money, invariably he will write an order rejecting bail but ensuring that you get it from the high court. Because if he grants it himself, he knows that he's in trouble for granting bail, especially in a high profile case. In the other cases, it's always easier for him to err on the side of jail than err on the side of bail, because bail is invariably a very discretionary, and there are, of course, judgments which have laid down principles on which bail is to be granted, but those always are contradicted by one or two of judgments, which say that no, bail should not be granted. So even if there are overwhelming judgments which say that these are cases where bail should be granted, he will invariably pick up that one judgment which says it should not be granted, and that one judgment will invariably come from a judge in the Supreme Court who has not done criminal ever in his life. So he ends up, he looks at everybody who is accused of any crime as a proper, criminal who should be behind bars, and he, writes one of those off judgments. So the trial court invariably is least interested in granting bail for these so many reasons. So one could be that very, very rarely you'll find a trial court judge, who shows the guts of granting bail where it is to be granted. So once you cross that hurdle, you are definitely inside for a couple of months, because by the time your matter gets heard in the High Court, and there is another very pathetic story as far as going to the High Court is concerned. Rebecca, or most of you are, fortunate to practice in the Delhi High Court and Supreme Court, where matters get listed. At least Delhi High Court matters get listed the next day. I go to Allahabad High Court, I go to Patna High Court. Allahabad High Court, a bail is not listed for more than a year. The first listing does not happen for more than a year. Patna High Court, a bail doesn't get listed for at least 6 months. So if you have been denied bail by the trial court, even in a hopeless case where you are supposed to you should have got bail on the very first date, the High Court doesn't hear you for months or for years together. So that again, makes your incarceration, sort of indefinite. I had the pleasure again of getting bail in a matter from Allahabad, from the Supreme Court. In spite of my bail being pending in the Allahabad High Court, I got a bail in a 32 petition in the Supreme Court, because I said that there is no point of my petition being pending there if it is not being heard. And Justice Indira Banerjee, I remember the prosecution, very vigorously argued that how can you hear his 32 if his bail is pending there? She says, what do I do if the bail is not being heard for a year in the High Court? I can't just let him remain inside. And that was also one of those frivolous cases where, bail should have been granted at the very first instance. So this is the big problem with the litigant. The other problem is that even if, and that's again a very big problem which the Honorable President also mentioned on Constitution Day, that when bail is also granted by the trial court, or when everything else gets satisfied and, and the bail bonds are to be filled up, or if the accused is unable to come with a bail bond, you continue to remain in jail. So there are cases where a person remains inside jail beyond the maximum term which he could have undergone, even if he had been convicted as an under trial, and he is not able to produce bail bonds, and he remains inside again. So these are, I would say, great flaws in our system of, and this is the poorest of the poor are the real affected, the tribals and the scheduled caste in small places where nobody is ready to come to them in their jail and to even talk to them. They don't have anybody for a bond, and they can't even they don't even have that monetary might to give a money bond also. So those are those other cases again, which so the large majority of the cases are either those poor ones who don't get it because for this reason that either they can't afford a lawyer, or when they can afford a lawyer and they get it, they are not able to satisfy the trial court with a bond. And the high profile cases get stuck because if the judge grants bail, then he will be viewed at as if he has done something wrong, and that is how the matter then travels up to Supreme Court. Now if the matter travels to Supreme Court again, the likelihood of your going to a judge, as Siddharth mentioned, or even Vivek mentioned about these criminal knowing judge, criminal justice knowing judge, like names he mentioned, of course. I remember even before that several names, but the Justice Pandian was one of those judges. Jayachandra Reddy was there. So there are several of them who knew criminal law and who would understand a criminal law, would understand the basics of criminal law. And one of the basics which the judges don't understand is, and it's very unfortunate even in Supreme Court, that unless you are actually proved guilty, you have to be presumed to be innocent. Now that is one of the basics of criminal justice system which judges don't understand. And with that if you end up in a court where the judge doesn't know criminal law as it is, he will just, because he'll hear the FIR, he'll just see the case made out in the FIR. That's all that he needs to know. He doesn't need to know anything after that, and the bail gets rejected. So this is the travails of a accused that happens as far as the bail versus jail jurisprudence is there. But fortunately, I mean, it's not such a gloomy picture. Fortunately, of late I'm seeing in the Supreme Court, a very recent past, I would say, where Supreme Court judges are looking into this aspect and are emphasizing that high courts and trial courts should grant bail, and they should be fearless in granting bail. And I hope the message percolates down, and this whole mindset changes of instead of jail versus bail, it should be bail versus jail. And people, don't feel, because ultimately if you get acquitted, what happens? I mean, these years that you ultimately give up inside the prison, away from your family and away from everything else, that can never be brought back to you. There's no way it can be brought back to you. So that's a real problem which the criminal justice system is facing.
May I just add a word or two to what Mr. Vikas Singh has said? Recently, the Supreme Court has granted bail to Indira Mukherjee, in that brutal murder case of her own daughter. Indrani Mukherjee has been granted bail. And bail, sorry, I think Justice Bhambani has just arrived, so we'll just take a pause. Yeah. So may I just, I'll just continue. Bail has been granted to Indrani Mukherjee in a brutal murder case of her own daughter. And bail has been granted, dehoars the merits of the allegations. It has been granted only on the ground that she has been incarcerated for about 4 or 5 years. Only a few witnesses have been examined. The trial is highly protracted, and therefore bail is granted. Now we find, as defense counsels, that judgment is not percolating into the criminal justice system. We are exhorting Indrani Mukherjee time and again, in the High Court or the Sessions Court. But there is a certain mindset, but it's a welcome decision. And then Justice Kaul in Antil's case, has stated very fearlessly that there is a tendency amongst judges to deny bail on the ground that they find the prosecution case to be weak. And they feel that, the prosecution case will end in an acquittal, but a kind of a moral conviction. So let's keep him behind bars for as long as possible. Ultimately, he will go scot-free. So there is a change happening, and I hope, these judgments will percolate into the criminal justice system.
So coming to another slightly different topic, any one of you can choose to answer this. The issue of backlog. I would have thought that the period when we were a little away from physical courts, the 2-year period during COVID, was the right time to do an audit of pending cases. But that wasn't done. When do you think will somebody look at the All India pendency and decide that some of these cases just have to be closed? Siddharth, do you want to...
I think it's impossible, very frankly speaking. If you take Allahabad High Court, you'll have to pass a legislation saying that all government appeals should be dismissed from a particular cut-off date. All revisions against acquittals which can't get converted should be dismissed from a particular date. And this is not on the criminal side only. This is a civil side problem. They have first appeals pending from 1967-68. So, it's not possible. With the kind of inflow that is coming, the outflow, if a judge in Allahabad High Court is dealing with 300 bail petitions in a day, 300. How is it possible for him to do? He's not there sitting there like some mule or a donkey who has to be just whipped and so you go on passing. If he passes, if he gives you bail, it is set aside by Supreme Court. He has not given reasons. If he gives reasons, it is set aside saying he has given too many reasons. He's given on findings of facts. So what is he supposed to do? I really feel for the judges. I'm very happy that nobody ever offered and I didn't become a judge. But seriously, it is a very thankless task. And of course, they have to have their view about the impact of the particular crime on the society as well. Everything can't be just judged like whatever we say as defense counsel. No, we would get bail even for any person, regardless of what he is accused of. But it's not possible unless there is either like for large states there's bifurcation of the state, or there is some ad hoc judges, the proposal for ad hoc judges that is there. Don't look at the cities, like big cities like Delhi or otherwise. The hinterlands, etc., have a huge problem. Huge problems, and then the process of appointment, which is very delayed. So therefore, it's a very, I don't think it's going to happen very soon, and we have to live with this backlog problem.
So Rebecca, very strongly feel that, and this is one of the problem which Vivek actually mentioned, in a different way, but really is the problem. So if the lawyers, firstly, the elevation to the high courts is not happening jurisdiction-wise. So when you have, say, so if you have tax lawyers and if you have income tax, criminal lawyers, you've got service lawyers, etc., all of them are getting slowly elevated. So there is no study being done of how many criminal judges, criminal law knowing judges are to be elevated in the High Court, and that is unfortunately that structured, is not happening, because and in the process of making people who know criminal law, the emphasis should be more on people who are doing work on the defense side rather than on the prosecution, because prosecution side, if they get elevated, the mindset remains the same. Prosecution, and that's the problem which we face day in, day out, that prosecution is supposed to say, if you say it's day, they're supposed to say it's night. No, sorry sir, it is night. I don't know how is he calling this 12 o'clock is midnight. So that's the kind of attitude of a prosecution lawyer. So if you make him a judge, the problems remain the same, because he will not, firstly, not be interested in proper disposal. Lastly, I have always felt that the quality of judges will make a lot of difference apart from this segregation of lawyers from the various jurisdictions being taken up, depending on the, so if there is a study of high courts, if it is having say 30% criminal matters in all, then 30% judges also should be looking at criminal matters. So that kind of study is not happening. And lastly, I would say that quality of judges makes a lot of difference, because judges have to be decisive, especially at the lower court, at the high court level. Supreme Court, where actually Supreme Court being the last court, which, you know, where you feel that iske baad to Bhagwan hi hai, Supreme Court is most decisive. 90% matters get dismissed on the first day. But high courts and lower courts, unfortunately, take a very long time to decide. And that is where the pendency goes up. I have seen some judges, you know, in various jurisdictions who have, you know, who know the law or who understand the law, whatever jurisdictions they've handled, they've tried to, you know, clear the pendency completely in that jurisdiction, in that court. So once the quality of judges improve, and that's the big take that I have on the, I can see Tarun Nangia sitting here. We had a chat yesterday on NewsX on this collegium system, and I have a very strong view that unfortunately the collegium needs to continue to appoint, but they need to reinvent themselves and ensure that good people get elevated as judges, and that's the only way we will be able to make a dent in reducing dependency.
Mohit, before you answer, since we are Delhi lawyers, I also like to flag another issue with respect to pendency. You see, if you look at Delhi courts, particularly the fancy Rouse Avenue courts, there are some 20-odd judges sitting doing nothing, one or two matters on their roster, because they are the PC Act judges, Prevention of Corruption Act judges. Likewise, they do a couple of PMLA matters, whereas a large number of sessions judges who deal with 302 and such like cases, their docket is overburdened. They have some 50 cases every day. Evidence doesn't get recorded because there's just this much you can do in one day. What is this fetish we have for creating more and more courts for corruption matters? Then you have special courts for MPs and MLAs. Why are we not prioritizing those criminal cases where people have suffered, where the human body is involved? And why are we looking at these so-called big ticket cases and allocating one judge for that one case?
Rebecca, this issue of pendency of cases, even the anchor is here, and Mr. Nangia and Justice Sikri was a co-panelist on this. During the pandemic, this issue of counting of cases and pendency of cases, we found, had gone up from 4.5 crores to 5.5 crores all over the country, in all jurisdictions. So one of the issues, rightly said by Siddharth, that you could have ad hoc judges, but that can be in the High Court or Supreme Court only, to dispose of the regular matters which have been pending for such a long time. Another issue which was also discussed is what Mr. Singh just said, Vikas Singh ji, that people who are trained in a particular jurisdiction, if they are asked to sit in those jurisdictions, I know it sometimes becomes boring for them to continue on the same field. After a year on the same roster, they would also want a change, because once elevated, they don't want to do the same thing again and again. But the speed at which they can dictate orders and decide cases with their experience at hand is definitely far higher than somebody who has never touched criminal law and wants to understand while sitting on the criminal law what is a criminal revision or what is an interlocutory order. So those kind of situations actually delay, because the lawyers sometimes presume too much. They presume that the judge would know this much and I don't need to answer or reply to the question of maintainability. So one day it is unnecessarily wasted on answering to that. So one date wasted means the same number of that case will add on to the docket of the other day. Now, as regards what you asked about Delhi, this fetish actually flows, unfortunately, from Supreme Court. They have some love and affection for all the PC Act cases because they are the only cases they feel are going right in the roots of this country, and the corruption is so rampant, and those quote-unquote corruption is rampant in the country. It is like a termite. It is eating at the roots of the society and all those things. That gives an impression as if all others are non-serious cases. Whereas corruption cases till about 2018 were only punishable up to 7 years. Today it has become 10 years. But you're right, PC Act cases, and despite and as a bar also, we have mentioned to the authorities concerned that the distribution is so lopsided that a magistrate, you give one magistrate the charge of special acts. And those special acts are running from minimum wages, payment of gratuity, payment of wages, Factories Act, and one after the other, insecticide, pesticide, everything. Those are all covered by special acts. And those cases are put before one man, Wildlife Act. Now, he has 200 cases before him. Even before a snap of a finger, he doesn't find the lawyer there present. He'll give a date. The minute the accused is not present at 10:15, issue warrants. Without realizing that the High Court rules say that you wait till 12 o'clock. But the man cannot wait. He has such a long list. And you're right, we pointed this out. In fact, though not permitted, we took snaps of court lying empty. And we showed it to the judges, the authorities concerned. Look, this is the lopsidedness. The list shows only 3 cases in the morning session and 1 case at 2 o'clock. Maybe some remand comes that will not listed. But 4 cases, and you have all the facilities in the newly constructed building, whereas the others continue to suffer. The other courts are suffering, one, because of the pendency, the burden, and mainly because of the mindset. The mindset is, एक अच्छी पोस्टिंग के लिए पहले मैं ज़रा अपनी AC improve करा लूँ. My ACR should be right. I should have those straight A's in the last 5 years so that I can be considered for a good posting. And dismissal of criminal cases is definitely a star, a badge for you, because then if you are convicting people, so you are an honest judge. That mark of honesty today is coming from the fact that you are not giving any relief to anyone. So there is an absolutely eerie kind of a weird kind of a thought that the entire honesty, the calculation of honesty and the perception of honesty is, if you are not giving relief to anyone, so every relief that is given is taken as a pointer towards your dishonesty or your likely dishonesty. Unless and until you have some freak cases who openly say, I am not likely to go get elevated, I am not in that list, because they keep calculating, especially the district judges. The minute they become a district judge, they start calculating, am I number 16? How many vacancies will be there? So now I should be very careful. I have even heard few judges say, and I'm sure Siddharth and you definitely would have heard, कि सर हाई कोर्ट ले जाओ, वहाँ मिल जाएगी जो मिलनी है. हमारे को क्यों कर रहे हो? 2 साल रह गए, पता नहीं कोई स्टिग्मा ना लग जाए. रिटायरमेंट के 2 साल रह गए, रहने दो. So the sir is right कि they'll write such a order which looks absolutely clean. Though it dismisses, it points out everything in your favor, notes all your contentions, and says, but at this stage, I don't think it is the right case. So the difficulty, Rebecca, is that even if we tell the authorities, we, for High Court, for Delhi, we'll limit ourselves to the administration in Delhi. But then the Delhi High Court is also every day receiving one or the other letter saying how lovely your judgments are, how you should take care of them, and Delhi is always in the eyes of everyone. So the Supreme Court, just 1.5 kilometers away, if it keeps on commenting upon the Delhi judiciary, Delhi courts, and Delhi system, then obviously this problem will continue. This lopsidedness is only because there is so much pressure on PC Act cases, that to the extent that now we have one judge in the High Court appointed for MP MLA cases, and I don't know whether Sir or Siddharth have had the occasion, but the other three of us know that particular roster has 100+ cases on an everyday basis. How do you expect a High Court judge in 5 hours of working to even listen to those 100+ cases? It's just not possible. And everyone wants his case to be heard. So there is a 20 mentioning list in the morning itself, because people who have item number 70 or effective 80, they know that it's not likely to come. And then we have Supreme Court keeping on saying that a sitting High Court judge has to be a member of a tribunal, of a particular tribunal, of this committee, of this session, or this board, Coffee Posa board, or whatever boards, different places. So if they have to also divert their attention and their time, they have that limited time only. What all can they do? So this pendency keeps on increasing.
Just to make the point of specialist judges, I remember when a bench of Justice Sikri and Justice Nariman was constituted on the tax side in 2016 or 17. They disposed of, by hearing on non-miscellaneous, just 3 days, within 3 months, I think more than 5,000 cases, just by hearing them on 3 days. And that's what you require. And the tax pendency became almost zero when Justice Sikri and Justice Nariman were presiding over that bench.
Okay, I think we have perhaps overstepped our time. So one last question to all of you, brief. In your wish list, if you wanted something to change with respect to the criminal justice system, what would that be? Starting with you, Siddharth.
I think specialist judges, that's what I would want.
All right. Mohit?
I think a hands-off approach by the Supreme Court, let the judges do and trust their intelligence and wisdom.
Okay, that's fair. The Supreme Court is here.
And I would say police reforms. If you do police reforms, then 80% of your problems of criminal justice system will get automatically sorted. Of course, I endorse what Siddharth and Mohit said, but since I was supposed to say my own, I thought police reform will be more appropriate if these two are already happening.
And so the last word to the author.
I would highlight 2 points on this. Malvestigation, I have coined this expression, malvestigation, in my book. Shoddy investigation must be checked when the investigation is being conducted. Not after 20 years, when the Supreme Court laments that this was not done and that was not done. Second, the magistracy of the country must give away the colonial mindset. You know, at the first point of time, when a case is registered, the man is arrested, he is produced before the magistrate. And the magistracy of the country should follow Arnesh Kumar and other judgments in letter and spirit. You know, if the arrest is not born out of necessity, he should be released. What happens is, he is arrested, and the legality of the arrest gets lost in the maze of the criminal justice system. The entire focus shifts on bail. So the legality of the arrest is never adjudicated. So these are the 2 reforms I feel are imperative.
Thank you very much, all of you, for spending a Sunday evening with us. Thank you so much. I hope somebody is listening to this conversation, and I hope we have some reforms. We have some sitting here. Thank you very much.
So I graduated from law school in 2022, and I've recently enrolled myself at the bar. As an intern and now a lawyer enrolled at the bar, I visit the Delhi High Court and the Supreme Court very frequently. Sometimes when we are just waiting for our case with our seniors, we go to the canteen and we order a coffee, a cold coffee of the Delhi High Court especially, or we sit at the criminal side bar room sometimes. And very often on the next table there's a group of senior advocates and other senior members of the bar. And you know, as a fresher at the bar, it's so intriguing. You want to know what they're discussing, you want to know what they're laughing about. Sometimes they're huddled up in a serious conversation and it's so intriguing. You just want to go over to their tables and ask them, "Sir, may I please join?" I think today this discussion that we witnessed was a sneak peek into what happens on that table with all the senior advocates and the senior members of the bar. Full of hard-hitting realities, practical insights, and legal jokes, of course. Before we move forward, I would like to thank all the panelists for their time. It was truly an honor to listen to each one of you. Before we move forward with our next segment and the moment that we all have been waiting for, the unveiling of the book, I would like to welcome Honorable Justice Anup Jairam Bhambani, the guest of honor today. At the risk of repeating my introduction for him, I would like to take you all over it once again. Justice Bhambani, our guest of honor today, is a sitting judge of the Delhi High Court. Sir was designated as the senior counsel in 2014. During his days at the bar, he has done some substantial legal aid work before various courts for the indigent embroiled with law, including in the field of juvenile justice and death penalty. He has assisted the Delhi High Court as an amicus in several matters involving issues of public significance. It was Sir's passion for justice which made him give up his roaring legal practice to serve as a judge of the Delhi High Court in 2018. A judge is known for his judgments, and I selected a few of his many gems that he has delivered till date. Recently, in a case dealing with a bail plea for an 18-year-old boy accused of a sexual offense under POCSO against a minor girl, he held that prima facie there was consensual physical relationship between the two, and though POCSO was intended to protect children from sexual exploitation, it was not meant to criminalize romantic relationships between young adults. In Muhammad Hakim, Justice Bhambani, while granting bail to an under trial who has spent 12 years in jail in connection with the 2008 Delhi serial blasts case, said, and I quote, "We must save constitutional rights from demise." We are pleased to have you and ma'am with us today, and I would like to request the audience to give him a big round of applause. On that note, I would like to request Justice A.K. Sikri, the chief guest today, and Justice Anup Jairam Bhambani, the guest of honor, to join us on stage for the moment that we all have been awaiting, the unveiling and the release of the book, Chaff and Grain, Guilt, Innocence and the Dilemmas of Justice by Vivek Sood.
with the unveiling. I have taken that also. You're a cheerleader.
Before we move on to the next segment, one piece of advice for our audience today. We only have 100 signed copies for the book available today. So be sure to grab yours quickly. Now, I would like to invite our very prolific guest of honor, Honorable Mr. Justice Anup Jairam Bhambani, to address the gathering today.
Let me first begin with a sincere apology for not being here at the appointed time, but I was under the weather, and in fact I was in two minds whether I could make it at all. That being said, thank you so much for a very warm reception. Dr. Justice A.K. Sikri, Honorable Judge, former Judge of the Supreme Court of India, Mr. Justice J.R. Midda, former Judge of the Delhi High Court, Mr. Vikas Singh, President SCBA, Mr. Mohit Mathur, President DHCBA, all the eminent senior counsels and members and colleagues of the legal and judicial fraternity. By origin, English is a foreign language. Writing is a dying art. If you visit a bookstore, go to a Full Circle in Khan Market or any other place, you get this distinct impression that just about anyone and everyone is writing a book. To use a rough and ready expression in Hindi, जो भी घर से रूठता है वो किताब निकालता है. However, when you have mastery over the English language, the skill of wielding the language in simple and straightforward text, which is a rarity, and if you are a consummate storyteller, and to add to that, you have domain knowledge garnered over 30 years of actual hands-on legal practice, then the position is different. It was truly enjoyable to get a glimpse of Mr. Vivek Sood's book, which is very aptly titled Chaff and Grain, Guilt, Innocence, and the Dilemmas of Justice. When I switched from science to law, so back in school and in college, I was a science types. When I switched to law, one of the predominant reasons was the topicality and the immediate relevance and relatability of the subject of law. As opposed to a career in science where you'd be probably sitting in a laboratory doing something quietly by yourself, nobody shares anything with you, you don't share anything with anyone, it's not live. As opposed to that, law, I found, with whatever little exposure I had at that stage, was a live wire profession. And that major reason for switching from science to law, for me, remains so even today. The essence of Vivek's book is just that. He effortlessly storytells some of the most macabre events of the last few decades. His choice of topics, of issues, of cases is, I think, most appropriate. And he explains in very simple, easily readable and understandable prose. The Talwar case, the Jessica Lal murder case, the case about Priyadarshini Mattu, the Unitek brothers. All these cases which have caught the public attention for the longest time during our lifetimes. He narrates the gist of the case He captures the essence of the plot, the problem, and connects it effortlessly, I thought, with what plagues our criminal justice system. So when we say, why do we only hear about the cases of the big guys, the rich guys, the important guys, I don't for a moment suggest that the system should treat the rich or the accomplished differently from the poor and the humble citizen of the country. But it is in these major cause célèbres that some very important points of law get laid down. And that inures to the benefit or to the disadvantage of many others. So therefore, the learning that these major cases present is something that we should all be interested in and try to understand. In particular, and I am quite impressed with this at my own level, is I must commend the rhythm of Vivek's writing. I enjoy writing. I like to focus on the nuances of a phrase, a turn of phrase, of the words used, of the length of sentences. I'm coming down to a bit of nitty-gritty nuts and bolts, but I commend him for the rhythm of his writing. It makes for very easy reading. But he does more than that. Vivek answers some of the most commonly asked questions on the criminal justice system, again, in his typical, simple, comprehensive manner, and also makes some suggestions going forward. So people often wonder when they read in the newspaper that, oh, this man killed somebody by an accident and he's been granted bail the very next day. It is hard to understand that killing alone does not invite a life term. There are offenses which are in law by statute bailable. But how many of us understand that? People often wonder that this man has got bail. Now he's footloose and fancy-free. Chutti. It's fine. It's all over. He's on bail. How many of us really understand the concept of bail, the restrictions that come with bail, the fact that the trial is still going on? These are some things which Vivek quite beautifully explains, I think, in the book. I would commend Vivek for his very easy-to-read, breezy style of writing, his prosaic tenor. And he also deals very pithily with some of the fundamental concepts, which we all should understand, because the criminal justice system affects everyone. And very few have any grasp or lucid understanding, whether specialists or laypersons alike, of how the criminal justice system operates. And as I always say, the true test of our entire legal system is the manner in which we treat the worst amongst us, the so-called criminals. That is what defines a civilization as opposed to a barbaric system where you're just hustled onto a city square and lynched in 2 days flat. Hurrah! Some of these concepts which Vivek deals with in his book are quite abstruse, they're quite obscure. Circumstantial evidence, for example, proof beyond reasonable doubt. He writes about this, again, as I said, with great simplicity, without any verbiage. These concepts in themselves are fairly complicated. To add to that some complex words and verbiage, I think is not desirable, and he avoids that scrupulously. All of us require a much clearer understanding, not deeper, but a clearer understanding of our justice system. Why I say not deeper? Because deeper comes much later. I have held the criminal roster on various occasions over the last 4 years. And I dare say that not just lay persons, but even legal practitioners are not clear about concepts. I recently had the occasion of hearing a central government standing counsel appearing in an SFIO matter, as always opposing bail, because we rarely do we get to the main matter, but bail is what we hear every day, who said to me, "Sir, charge sheet has been filed. This lady has been sent up for trial, and hold your breath," she said, "she is guilty." I said, "Excuse me? Should we then bother with any trial or any appeals at all, or should we just say that you speak that she is guilty, so she is guilty?" Now, this was not a lapsus linguae, I would say. This was the approach of many of us. It is the approach of many of us. Now, from a cursory reading of the book, I have not read it cover to cover, but I find that Vivek seems to have a visceral feel for the subject and a genuine concern, and I'm sure that comes from his experience as a practitioner. So he has this very clear, deep feel of the pitfalls of the system, and he highlights those, he flags those very beautifully. Now, I do see that some views and opinions expressed by him, many of us may not agree with, including me. I may not agree with all that Vivek has said in his book, but then they are opinions. We must appreciate that. They are opinions. One of my favorite authors, Walter Lippmann, an American author, commentator, wrote about the press, and this is what he said. "Press does not tell us what to think. It tells us what to think about." I think that would apply equally to an author to a book. A book does not tell us what to think. It tells us what to think about. This diversity of views is what finally brings out the best view in society, which is best for society. And again, Walter Lippmann, if I may quote him again, he says, "When all think alike, then no one is thinking." I must confess that I've been wanting to write a book. At present, I suffer from a certain temporary disability. My daughter has been prodding me to write a book, but I can't, as of now. I have not been able to put pen to paper or finger to the keyboard. But one day, I will write a book. I compliment Vivek for the book, and I think it should grace everyone's library. And if I may just digress a bit, this is something, it's a quote. Looking at the mood of the House, it may not be directly pertinent to the matter, but looking at the mood of the House and what partial discussion I heard, and this quote I noticed in a recent event that Honorable the Chief Justice of India attended in Bombay. He spoke there. But this quote gives me goosebumps, and I want to share it with you. It's Allama Iqbal, who says, "सितारों के आगे जहां और भी हैं, अभी इश्क के इंतहा और भी हैं। तू शाही है, परवाज है काम तेरा। तू शाही है, परवाज है काम तेरा। तेरे सामने आसमां और भी हैं." Thank you so much. Jai Hind.
Thank you, sir. Your kind words have definitely given us food for thought. One thing that I think I am genuinely taking back from sir's speech is, the press does not tell us what to think, but it tells us what to think about. Sir has simplified the freedom and the freedom of speech and expression so beautifully through this quote. Thank you, sir, for your kind words. I'm sure, just like me, the audience is mesmerized as well. Now, I would like to request the man of the hour, the chief guest, Justice A.K. Sikri, to join us on stage and kindly address the gathering. Sir, over to you.
Thank you very much for your kind words and kind introduction. My esteemed brothers, Justice Bambani sitting on the dais and Justice Midha sitting off the dais, the two presidents, one of the highest court, that is Supreme Court, Mr. Vikas Singh, and the other most prestigious court in the country, Delhi High Court, Mr. Mohit Mathur. Star of the day, Mr. Sood, Mr. Siddharth, Rebecca, Nisha sitting there, all other persons who have assembled here today to witness the grand launch of one of the best books on this subject, and rather, as I would say, this heading itself suggests Chaff and Grain, and the manner in which Mr. Sood described the jurisprudential thesis, and which has become the debate of the day insofar as Indian criminal justice system is concerned. And I'm hopeful, and I think that this is going to the idea which you have given, as Mr. Bambani, Justice Bambani said, it is going to generate much jurisprudential debate, whether we have to go by the old notions or well-tested notions, and which is the principle accepted in American jurisprudence or American criminal system, as you said, or the doctrine of necessity, this Chaff, Grain and Chaff, which Indian Supreme Court has devised. Actually, as I saw, this is in one judgment, Money versus State. The Supreme Court has said much earlier that it is the duty of the court to separate grain from chaff. Where chaff can be separated from grain, it would be open to the court to convict an accused, notwithstanding the fact that evidence has been found to be deficient or not wholly credible. Falsity of material, particular, would not ruin it from the beginning to end. The maxim falsus in uno, falsus in omnibus has no application in India. And the witness or witnesses cannot be branded as liar. There is a long quote, I am not going into that. I think that is the genesis of the debate, which is the fulcrum of this book. Before stating much or little more on that, I won't say much. Let me congratulate Mr. Sood, and I feel envy of him. 7th book, my goodness. That too from the pen of a person who is a designated senior advocate and who has a lot of professional work as well. Why I say so? I know that even when I was lawyer, of course I had been writing articles, but after judge, even in the High Court, in the Supreme Court, I had thought of writing books. When I retired as Supreme Court judge, at least 3 endeavors of mine, half-cooked, could not get time to complete that. And at the time of my retirement, I thought that within few months I'll be able to complete this. But it seems I have not retired, and therefore I don't even find time today. Of course, it is my New Year resolution this time, and I don't know whether I'll be successful or not, that at least 1 or 2 of those should see the light of the day in the year 2023. But I feel amazed that how, when I compare myself with Mr. Sood, that a person, and I couldn't find time to complete those books, and here's a person who is coming out with 7th book. Maybe time management, how it should be done, I have to go to him and learn lessons from him. I was reminded of one very celebrated book all must have seen on the subject of management, what they don't teach you in Harvard. And I think what they don't teach and those management lessons which that book gives, when it comes to time management, Mr. Sood write a book on that also, how we are in a position to write books while carrying out our duties, professional duties as well, be it the duty of a lawyer or a judge like me. Insofar as further address is concerned, I would not take time, and I think there are 3 reasons which have made my task easier. Number 1, the very lively debate by the panelists with Rebecca as moderator. Most of the issues, some of which I wanted to say in my address, have been so thoroughly probed into and discussed. Therefore, I need not say much. And insofar as this book is concerned, so eloquently and remarkably, Justice Bambani has already told you about the book. So and the third reason is, I think this is now almost time for dinner as well. So I should not stand between you and the dinner for a longer period. So therefore, I'll spend just some time in coming back to the theme of the book and trying to discuss some of the jurisprudential aspects of it and what is the reason that this principle of Chaff and Grain needs to be discussed, and whether with this principle we are heading towards attaining justice or justice becomes casualty, and many of these examples were given by the panelists. You see, it says Chaff and Grain, and the subheading, guilt, innocence, and the dilemmas of justice. On the one hand, we have those persons accused of the crime who have committed the crime, and whether we are able to, the judiciary is able to return a verdict of guilt against them. On the other hand, there are, we know it, and that has been discussed in detail by the panelists, particularly the role of our celebrated police in roping in many innocent persons and filing charge sheet against them, and ultimately it is whether they would be proved innocence or they would still be convicted. So therefore, on the one hand, there may be a person who is genuinely, who has committed the crime, and the challenge before the judiciary is that to convict him. On the other hand, there are innocent persons who have not committed, and again the challenge before the judiciary is to ensure that such persons are not convicted. They are declared innocent by the courts as well. As it was said, and everybody knows, the old dictum or the golden principle is that 10 persons who are guilty may go unpunished, but 1 person who is innocent should not be punished. I feel in today's world, and again that is relevant to the jurisprudential debate behind this Chaff and Grain, the first part of this principle doesn't hold very good. Reason is simple. Of course, we still maintain that an innocent person should not be held guilty, And that is the principle of criminal jurisprudence, and that is why another celebrated principle that unless the guilt is proved, a person is treated as innocent. But at the same time, when those who are guilty, they go unpunished, that also, as far as society is concerned, it creates fear in the society as well. It erodes trust in the judicial system also, that the judicial system is not in a position to or is not convicting those who are guilty. And let me share few anecdotes here which would, I think, will tell how the balance is to be created, and there are cases of both sides. First case, which during your discussion Rebecca had also mentioned about our judgment, because it's not I'm proud of the fact that we gave that judgment, but I was really frightened at what was happening when such persons are ultimately found to be innocent and we had freed them. Maybe you are not that lucky, Rebecca, the case with which you started that debate, that you ultimately lost insofar as conviction is concerned, but succeeded only on the sentence that from the death sentence it was converted into life imprisonment. But here was a case which she mentioned, and the history of this case is really gross. 5 Adivasis were charged of committing murder of, they had liquidated the entire family, 5 or 6 persons. This was the charge. Those persons in that they were in some remote area in jungle, and the charge was these Adivasis just to rob them. They had gone there and the entire family of 5 or 6 persons was murdered. Trial court convicted, and looking into this ghastly murder where 6 persons are murdered and with this motive of committing robbery, sentenced them all 5 to death. High Court affirmed the death sentence and conviction as well. Supreme Court dismissed the special leave petition in limine, and death sentence was confirmed. Luckily, after some time, and I'm also a part of that constitutional bench judgment, where this judgment came that if the death sentence is there, such cases should not be dismissed in limine, number 1. And number 2, which was authored by Justice Roynton, that was his first judgment in constitutional bench presided over by Justice Lodha at that time. I was part of that bench. And second was it should be heard minimum by 3 judges. So this special leave petition was dismissed by 2 judges. That was a reason on the basis of which they could file review petition. Of course, review petition through legal aid. They didn't have any means to engage any lawyer. Because of this judgment, review petition was entertained. It was ultimately now, its history. Not only thereafter, leave was granted, and when the matter came for final hearing before us, we found that there was no credible evidence. The entire, and if you people have read the judgment, there are, actually even the police is castigated in the manner in which they did the investigation. Lopsided investigation, and the kind of evidence, so-called evidence, which was produced, and it was unfortunate that that was not only believed by the trial court, but even if the evidence which was produced, because we came to the conclusion that was not even sufficient to hold them guilty. And even High Court had upheld the conviction and affirmed the death sentence as well. Now this is a case, but in the meantime, I think they must have languished in jail for 10 to 12 years. And why I said in the beginning that not that 16 years. Why I'm not that okay, I did justice and that gave some peace of mind to me, but I was disturbed as well. Because this is 16 years, and after that 10 years, when they have been held guilty and they have to face death sentence, how they would have spent those 10 years when death sentence was staring at their face. I mean, this is, we have to see from that angle as far as victims are, the innocent people are concerned. On the other hand, I am reminded of that Nitish Katara's murder case. This came to me when I was sitting as a single judge and for bail, etc. Neelam Katara was her mother, his mother of that person who was murdered, the boy was murdered, was prosecuting that case. And what kind of gimmicks were adopted, tactics were adopted in order to ensure that trial doesn't take place. For 4 or 5 years, I remember how I ensured that at least trial should take place, because for 3 or 4 years, the girlfriend or so-called girlfriend of Nitish Katara who was sister of the accused person, she was not coming. She had been sent out of India. And how she should be produced? She was not coming. And here, of course, why I say so, a person is ultimately held guilty. And here's one case where a person should have been, he is held guilty, so we presume that as of today, he is held guilty rightly by the law. And so such a person, how they can avoid. Another case came before me. It was one girl who was working. She was in a private employment and she had filed a case of lodge a complaint under 354 against her employer in a private company. And matter when I was sitting on the criminal bench of the High Court, at that stage this 482 petition was filed for quashing. I was little suspect. Both of them were there. They said that we have compromised the matter, we want it to be quashed. But again I thought that let me have some little probe into this. I called that girl in my chamber. I asked her that, look, tell me very frankly, because many times there is a tendency of filing false cases. Is it, don't worry, I won't say anything, I'll simply quash. If it was a false case and you realize that case was false or whatever reason. And for compromising, I think she was given some monetary compensation also by the employer. She was offered that. She told me, sir, it is not so. If you believe me, it is a genuine case filed by me. But what should I do? I am a girl. I had to leave that employment. I've got another employment. And the job which I've got 2 months ago only, if my new employer comes to know that against previous employer, I had filed this complaint and it is again a private employment, and if he, again this employer also terminates me. And above all, I have now been engaged. I'm going to get married. It was sometime in September and she said that my marriage date is fixed in January. If my fiancé come to know of it, I don't know how my in-laws would behave. And what is happening on the other side? 4 times I had gone to the court, but my testimony was not taken. For one reason or the other, case was adjourned. And now I am at this crossroad. If I take leave and want to come to the court, and if my employer comes to know, or somehow my would-be in-laws, they come to know, where would be my fate? And therefore I have compromised. Now see both the sides. That's why I wanted to show both the sides. A case on the one hand and these two cases on the other hand. And therefore, many times, and I remember in one of the cases in Supreme Court, I had to write about this, where it was a case under POCSO, where what had happened ultimately, it was a complaint filed by father of that girl who was 8 or 10 years of age, and ultimately turned hostile when he gave witness, came in the witness box. Father, not what he had said, his statement under section 161 or on the basis of which FIR was registered, ultimately backs out. And therefore in that judgment I remember I had to write it, I had written almost that what are the circumstances under which witness become hostile, and why witness protection program is very much needed and warranted in order to have robust criminal system in this world. And here, in these circumstances, with these examples, I wanted to tell you the relevance of this topic. And really, Mr. Sood, I admire you for taking this topic for discussion. And the kind of treatment which you have given, it's remarkable, much of which is said to, explained by Justice Bambani. And therefore, judges always, and that is, it becomes the duty of the judge. If we say something, and again going by Indian conditions, that under what circumstances Indian persons or Indian people, starting from police, when even a person who has committed a crime, and police knows it that he has committed a crime, but is not having sufficient evidence, how we know, and you people know more, because you have discussed a lot about that there should be, those persons should be appointed as judges or criminal judges who have the criminal background. I agree with that, but I was not from that background, so I may have poorly done a poor job as a judge on criminal side. I'm not too sure about it. So there, the bar is the judge of judges. But what I feel is, at the end of the day, if you have, and that I always have said and have told to judges whenever I have been going to judicial academies also for training, that at the back of that mind, that sense of justice and value for human rights. And if you are sensitive to human rights, and criminal law should be treated as a subject of human right, and not merely because it is given a stepmotherly treatment also sometime when it comes to the reforms in the criminal justice. But again, only giving one example even of bail, I had been telling judges when I go there, you know it, when a person has applied for bail, even if you give adjournment by 1 day or delay, if the person was entitled to bail and delayed by 1 day or 2 days, you have deprived him of liberty for those 2 days, and you are responsible for violating Article 21 of the Constitution. That you should keep in mind. That should be the ethos while going into the applications of bail, apart from the legal rules. But what I was telling was that, look, at the end of the day, when this is the challenge before the judiciary, and under Indian conditions, when we know, so one side of looking at it is when we know that even the police, as I said, would know that a person has committed crime. Of course, police ropes in, as I said earlier, also many innocent people as well. But many times a person who is caught, people know that he has committed crime. If you remember that dialogue of that film, that LLB, Munna Bhai, where the judge says, वकील साहब, पहले दिन हमें पता चल जाता है कि जो सामने आया है इसने अपना क्राइम किया है या नहीं किया. हम सोचते रहते हैं सबूत कब आएगा, सबूत कब आएगा, सबूत कब आएगा. And many times, in order to get that sabut, the police also takes wrong turn, and Section 27 Evidence Act is the best handle for them. They would either plant the weapon of crime and then get it traced through that person, or even if it is genuinely found, but then if it is not covered by Section 27, they will say it was on his statement this weapon of crime was discovered. So this, it is, I mean, there is again another very interesting song, Seedhe Raste Ki Ye Tedi Chaal Hai, maybe for good purposes, but we don't know. It is difficult to believe police. And therefore, but another interesting thing is when the matter comes before the court, as everybody has discussed, first there has to be a proper investigation, whether proper evidence is collected. Many times police knows if they want to see ultimately that yes, they are under pressure. He is a person who has committed crime also, but if they have sided with him, that accused persons, they will not collect sufficient evidence, will give up the evidence which could be and file a charge sheet with insufficient evidence which will ultimately result in acquittal. Second stage is prosecution. Even if the material which was collected, whether the entire material is produced or not. So the role of the judge comes then. Whatever is produced before the judge has to evaluate from there whether sufficient material is produced before him, which shows that the guilt is proved beyond reasonable doubt. If that is not done, naturally, judge will acquit. And many times judges are accused, and very rightly said, that many times because of the pressures, I mean 2 or 3 examples which one Mr. Dave gave, that the judges feel that this man would be acquitted but he may have committed crime, so let us not give him bail and let him remain in jail for 3-4 years. Or that this person will be ultimately acquitted, but the crime is heinous, so bail should not be granted at all. Now, in these circumstances, when we know many times when even the evidence is produced, even oral testimonies, that when it is prosecution, police would say what should be said, what should not be said, and sometimes some things are tutored which did not happen and the person has said. But maybe excluding that, in respect of crime, what he has said is correct. So if we don't apply the principle of Chaff and Grain, then in such circumstances it may lead to denial of justice, that we would not be convicting the persons who are really guilty. And we have to go by what is happening in this country. It has to be an indigenous approach. On the other hand, yes, because of this reason, and many times because it is very, very difficult task, challenging task, the judges may commit error, and judges may also convict those who are innocent. So therefore, it is a really very interesting debate, and I think it should generate, Mr. Sood, what you have said, much more jurisprudential debate on this, and whether the way Indian Supreme Court is going on, and this grain and chaff mechanism, as you said, doctrine of necessity, or as a principle of necessity which is introduced, whether it is correct, which may be more practical, or if we apply this principle strictly in criminal law, whether it is anathema to the criminal jurisprudence. So I congratulate you on this wonderful endeavor, and I hope that it will generate more and more debate. Thank you very much.
The approach adopted by Justice Sikri as a judge has been unique, because Because while he is one of the most forward-looking and adaptable judge that this system has seen, his insight is rooted in history, the Constitution, and an unparalleled appreciation for the rule of law. Lastly, I speak for everyone in the audience. We look forward to the launch of your book, sir, as well as Justice Bhambani's book. Before we move forward, can we please have a huge round of applause for the chief guest, the guest of honor, and our panelists today. Mr. Harish Salve, Senior Advocate and King's Counsel, has been kind enough to pen the foreword for the book, and I cannot find more suitable words than his to describe the contribution that this book makes to the society today. He says, and I quote, "We owe it to ourselves and to the generations that would follow to fix what has gone wrong and to strengthen what is right. And this book is a must-read for those who are ready and willing to engage in this task." As we celebrate the launch of this book, let's also remember that this is just the beginning. It's time to start a conversation, spark a change, and make our criminal justice system a just and fair one for all. With this, I would like to conclude and invite my father to give the vote of thanks today.
There's a beautiful thought I came across on gratitude by Jack Canfield, who co-authored Chicken Soup for the Soul. And I quote, "Gratitude is the single most important ingredient of living a successful and fulfilled life." I've always believed that no book is an individual effort, even though the author gets all the credit. I'm deeply grateful to Honorable Mr. Justice A.K. Sikri, former Judge, Supreme Court of India, for adorning this evening as the chief guest. I'm deeply grateful to Honorable Mr. Justice Anup Bhambani, sitting judge of the Delhi High Court, for gracing this occasion as the guest of honor. I'm deeply grateful to Justice Sikri and Justice Bhambani for appreciating my work. I feel humbled by their kind words and motivated to continue this journey of writing and expressing my views on contemporary and complex legal issues. I'm grateful to Justice Midda for being present out here. He was my guru. I started my career with him. He taught law in the law faculty to our batch. Then I joined his chamber as a junior. So I owe a lot of my success to Justice Midda. I am deeply grateful to Mr. Harish Salve for penning the foreword to this book. The foreword speaks of his eminence and deep knowledge of law and criminal jurisprudence. It was wonderful to share the stage with him recently at the House of Lords in London. I am deeply grateful to Dr. Vivek Sood, Chairman of the Prime Minister's Economic Advisory Council, and to Mr. K.J. Alphonse, former member of Rajya Sabha, Minister, and also known as the Demolition Man by Time magazine, for having endorsed my book with their blurbs. I am grateful to the entire teams of Bloomsbury for giving life to my lifeless manuscript. I take this opportunity to especially thank Mr. Praveen Tiwari and Mr. Nitin Valecha of Bloomsbury for their continued support to this book. I am deeply grateful to my co-panelists, Mr. Vikas Singh, Senior Advocate and President, SCBA. Mr. Vikas Pava could not make it. Mr. Mohit Mathur, senior advocate, my good friend, President, Delhi High Court Bar Association. I must share a thought. Myself and Mohit got designated as senior counsels on the same day. So we share that date with each other. I am deeply grateful to Mr. Siddharth Dave, senior advocate, for participating in the panel discussion. And Mr. Siddharth Dave, he came on my invite at the last minute, so I'm very grateful to him. I am deeply grateful to Ms. Rebecca Mammon-John, senior advocate, for having brilliantly anchored the discussion on criminal justice. My co-panelists and anchor are leading criminal side lawyers of the country. I am grateful for them for having carved out time for this evening out of their busy schedules, and that too on a Sunday, which is a busy day with Monday matters in the court. I am deeply grateful to the entire team of LiveLaw for live streaming this event globally through YouTube. And I am grateful to Dinesh, Haritima, Urvashi, Ronnie. I am deeply grateful to my lovely wife for supporting me through all these years in the legal profession. I must share this thought. When I leave for the court in the morning, she is chanting shlokas. And when I return back late in the evening, she is again chanting shlokas for her well-being. So that's I am a firm believer of good luck and good karmas. They are two sides of the coin and coexist. I must share with you all today the sources of my good luck and motivation to do my karma with passion and commitment. My younger daughter, Hansavini, is my lucky charm. She is the soothing balm of my life. She is studying culinary arts, and whenever she is home from her college hostel, our kitchen is a mini restaurant with mouth-watering food being cooked by her. The good luck behind this book comes from Hansavini. I have been trying to write this book for about 10 years. I wrote 50 pages, 100 pages, 150 pages. I wasn't convinced, and I would put them in a bonfire or I would put them in a bin. Then came the pandemic in March 2020, and hence we had the virtual hearings in the court. Here entered my elder daughter, Ramayani, who was then in her 4th year of law. She would set up my virtual hearings, and we would spend hours and hours together in our beautiful study on the terrace. We would discuss legal issues, judges, and whatnot. We are both dreamers, myself and Ramayani, we are both dreamers. We would make travel plans post-pandemic, covering the entire planet. And our family has this group, the group of 4. We've called it the Sood Travel Agency. So that's when I shared with Ramayani my inability to write this book on the Indian criminal justice system. Her simple, magical words still echo in my mind. She said, "Father, just write 7 essays containing your take on the Indian criminal justice system. With your experiences as a defense counsel, having defended thousands of accused men, your book needn't be theoretical. Rather, make it an interesting read for anyone interested in knowing how our criminal justice system functions and malfunctions." This is the trigger point of this book. I have dedicated this book to Ramayani. This book has seen the light of the day because of her. Ramayani is my karma motivator. She continuously motivates me to do better than yesterday and excel in my professional endeavors each day. I am again grateful to Ramayani for playing the role of Master of Ceremonies this evening with eloquence. I am deeply grateful to my parents for giving myself and my sisters the best of education and the best of everything they ever had. My father gave me the freedom to dream big, achieve my dreams, and taught me to be a people's man. I must share another incident of childhood. you know, we would be traveling in the train and my father would make friends with the co-passengers, strangers, and you know, very soon they would be home for breakfast and lunch and we would be enjoying a vacation in their home in Kanyakumari or Srinagar. My mother has taught us the significance of contentment. I realize today that there has been a perfect blend of ambition and contentment in my life through my parents. I am grateful to my younger colleagues working in my chamber who helped me with the research of this book. Last but not the least, I am grateful to every member of this audience for making this evening truly special for me. I have friends here from my law faculty days, from Mayo College, from the corporate world, colleagues at the bar, golfing buddies, my relatives are here, my brother-in-law Sadashiv is here, my sister Priyanka is here. I am grateful to all of you for making this evening so special and memorable. It's a celebration time now. I think we've had enough of criminal justice. Now we must do justice to the bar that is open and the delights of Dampukt and Bukhara. Thank you. Please join us for this celebration. Thank you.
She has child is the father of my